Hello and welcome to this, our third seminar in the Davis Blank Furnace series, Commercial Lease Termination and Renewals under the Landlord and Tenant Act 1954. The series is designed for surveyors, property agents, in-house lawyers and landlords and tenants themselves to assist them navigate the world of commercial landlord and tenant matters. My name is Sean Hackett and I'm a partner and the head of the Davis Blank Furnace Property Litigation Department. So let's get started. In our second seminar, we examined the termination process for protected tenancies under the Landlord and Tenant Act 1954, which I will refer to as the Act. We discussed how qualifying business tenancies continue automatically under sections 24 of the Act upon expiry of the contractual fixed term in their lease, unless terminated via specific mechanisms in the Act, such as the Section 25 notice by a landlord, the Section 26 request by the tenant, or the Section 27 notices by the tenant wishing to vacate. We highlighted the strict requirements for form, content, timing, and service, and the common pitfalls that can invalidate these notices. Today, we build on the foundation by assuming a hostile Section 25 notice has been served by the competent landlord, or a tenant Section 26 request has been met with the landlord's counter notice under Section 26(6) of the Act, opposing the grant of a new tenancy on one or more grounds. The relevant section of the Act for today's purposes is Section 31. Let's start by briefly looking at what Section 31 of the Act provides. Under Section 31, a landlord may oppose the grant of a new tenancy only on one or more of the 7 statutory grounds listed from A to G. Grounds A to C are discretionary and fault-based, meaning the court must decide whether the tenant ought not be granted a new tenancy in view of their conduct. The landlord does not need to pay any compensation to the tenant when terminating a tenancy based on these grounds. In contrast, grounds D to G, which we will cover in our 4th seminar, are generally non-fault based and relate to the landlord's intentions or circumstances. The court will always apply a 2-stage test when considering the grounds of opposition. These are Stage 1, factual establishment. The landlord must first prove, on the balance of probabilities, that the factual basis for the grounds of opposition actually exist. And then we have Stage 2, which is the ought not to be granted phase. It's discretionary. If the landlord succeeds at Stage 1, the court moves to a discretionary value judgment based assessment. And here the court must decide whether, in all of the circumstances, the tenant ought not to be granted a new tenancy. The breach may be proven, but it does not guarantee a landlord's victory. Importantly, the grounds upon which the landlord seeks to rely must be specified in the hostile Section 25 notice or the counter notice to a Section 26 request. That is important because no new grounds can be introduced later. In addition, and this is when we come to look at the grounds themselves, we will note that they make reference to the phrase holding as opposed to premises. I want to pause there and look at the meaning of holding. The holding is that part of the premises demised by the lease, which is occupied by the tenant for business purposes. And that's really important. Our focus today is on opposed lease renewals, specifically the fault-based grounds under Section 31A to C of the Act. These are often termed the tenant fault or misbehaviour grounds because they relate to the tenant's conduct during the tenancy. The importance of this topic cannot be overstated, because for a landlord, successfully proving one of these grounds is the only way to regain possession of their property without having to pay compensation to the tenant. For a tenant, understanding these grounds is essential to mitigate the risk of them losing their business premises. It's also important for advisors such as surveyors and agents. They'll find this session particularly useful when counselling clients on lease management and their renewal strategies. It is worth remembering that the purpose of the Act is to protect the business interests of the tenant, which are affected by the approaching termination of their current lease. The default position is that the tenant has the right to a new tenancy unless the court exercises its discretion not to grant the tenant a new tenancy. Lord Justice Morris, in the case of Lyons versus Central Commercial Properties London Limited, referred to that discretion in the following terms, and I quote, "It is to be noted that the discretion is one whereby a tenant may be deprived of that which under the Act he was in a position to receive. The discretion does not operate to give something, but to take something away," end of quote. And that's particularly important. If proceedings are issued, typically by the tenant applying to the court for a new tenancy under Section 29 of the Act, the court will list the hearing of the grounds of opposition as a preliminary issue. It will hear evidence and then decide whether the tenant ought not to be granted a new tenancy. The burden of proof always rests on the landlord, and the evidence put forward by the landlord must be compelling. Vague assertions or unsubstantiated allegations will not be sufficient. When considering whether one or more of the grounds for opposition have been proven, the court takes a holistic view, considering the entirety of the tenancy and the tenant's behaviour rather than isolated snapshots of the tenant's conduct. This approach balances the Act's policy of protecting tenants' investments and goodwill against the landlord's rights to manage their asset effectively. If the court decides that it ought not grant a new tenancy, it will dismiss the tenant's claim for a new tenancy pursuant to Section 31 of the Act. We begin with ground A, and I'm going to quote from the statute. "Where under the current tenancy, the tenant has any obligations as respects the repair and maintenance of the holding, that the tenant ought not to be granted a new tenancy in view of the state of repair of the holding being a state resulting from the tenant's failure to comply with the said obligations." In essence, this ground applies where premises are in disrepair due to the tenant's failure to comply with repairing covenants in the lease. It is not necessary for the disrepair to be severe enough to warrant forfeiture. Even moderate disrepair can suffice if it stems from the tenant's breach. The court assesses the state of repair not solely at the date of the hearing of the preliminary issue, but throughout the tenancy term. In the case of Gill versus Lees News Limited, the tenant, operating a newsagent, had allowed the property to fall into disrepair. Although the tenant undertook remedial work shortly before the trial, the Court of Appeal held that the judge must consider the tenant's historical performance. Lord Justice Lewison emphasised that a lamentable record of performance with last-minute repairs does not automatically entitle the tenant to renewal. The court must weigh whether it is fair to compel the landlord to continue the relationship with such a tenant. However, it was also said in Gill that it would be a rarity for a landlord to be unable to establish some breach of repairing obligations at the date of trial, acknowledging the fact that it is almost impossible for a tenant to comply perfectly with their repair obligations, and every tenant will have been in breach of their repair obligations at some point during the tenancy. The Court of Appeal in that case ultimately exercised discretion in the tenant's favour, finding that the breaches, whilst present, were not so egregious as to outweigh the tenant's long-term occupation and the potential loss of their business. This decision underscores the discretionary nature of the ground. The court balances the severity of the breach against factors such as the tenant's remedial efforts and the impact on the landlord and the tenant's goodwill. Moving now to ground B, and I'll quote again, that the tenant ought not to be granted a new tenancy in view of his persistent delay in paying rent which has become due. This ground targets habitual late payment of rent, regardless of whether arrears are outstanding at the time of the hearing of the preliminary issue. The key word is persistent, which implies a pattern rather than isolated incidents. Substantial arrears are not required. The focus is on the frequency, duration of delays, and the inconvenience caused to the landlord due to the additional administrative burden placed on the landlord in having to deal with the arrears of rent. Once again, the court examines the entire tenancy history, and even if the arrears of rent are eventually paid by the date of the preliminary issue, this only means that there are no arrears at that point in time. The court will still consider historic delays, and in Gill versus Lees News Limited, the Court of Appeal considered rent delays alongside other breaches, noting that while the delays were not the primary issue, they contributed to the overall assessment of the tenant's reliability. In that case, the tenant had a history of paying rent late on multiple occasions, sometimes by weeks, but had cleared all arrears by trial. The court held that persistence is evaluated holistically. Factors include the number of late payments, the extent of delay, and whether they cause genuine prejudice to the landlord, such as cash flow issues or additional administrative costs. Ultimately, the court found the delays insufficiently persistent to deny renewal, but the case illustrates that landlords can succeed if they demonstrate a clear pattern impacting on their operations. Ground C is a broader ground, and I'll quote again, that the tenant ought not to be granted a new tenancy in view of other substantial breaches by him of his obligation under the current tenancy, or for any other reason connected with the tenant's use or management of the holding. Ground C is a catch-all provision that comprises of three parts, all of which must be substantial. The first part covers breaches not falling under grounds A or B, which we have covered. The second part encompasses reasons linked to the tenant's use, and the third part encompasses reasons linked to the tenant's management. And pausing there, the second and third parts of ground C can cover conduct that is not a strict breach of covenant, but is nevertheless detrimental to the landlord. The phrase tenant's use or management of the holding is not defined in statute, but has been interpreted through case law to capture distinct yet overlapping aspects of the tenant's relationship with the premises. Broadly speaking, use refers to the tenant's practical day-to-day utilization and operational activities within the holding. This includes how the tenant exploits the property for its intended business function, such as adhering to user covenants that dictate permissible activities, for example, retail, trading, or office operations, or ensuring the premises are actively employed in a manner consistent with the lease, for example, keep open dates and times. In the case of Jochus versus Ussel White, the Court of Appeal held that a tenant's failure to comply with the user clause requiring the premise to be kept open for business constituted a substantial breach connected to use, as it directly impacted the operation vitality of the holding. The court emphasised a positive obligation on the tenant to keep open a business that complied with this covenant, illustrating that use as tied to functional ongoing engagement with the property rather than simply mere occupation. In contrast, word management encompasses the tenant's broader administrative oversight and stewardship relationships and responsibilities over the holding, extending beyond daily operations to include how the tenant handles legal, contractual, or relationship aspects that affect the property's integrity or the landlord and tenant dynamic. This might involve managing rights connected to the holding, for example, rights of way, ensuring compliance with non-operational obligations, or addressing disputes that could prejudice the landlord's reversionary interest, for example, permitting a trespass on or over the holding. The terms are not mutually exclusive. The courts often consider them together because the word or in the provisions allows reliance on reasons linked to either or both of them. In the case of Gills versus Lee's News Limited, the tenant's history of minor breaches, including unauthorised signage and waste issues, and litigation conduct were assessed cumulatively under Ground C, with management capturing the tenant's overall reliability in overseeing the holding, while use related to specific operational lapses. In Gill, the Court of Appeal confirmed that the assessment is not confined to the trial date, but again spans the tenancy, rejecting a single snapshot view. Just because the factual preconditions which the landlords need to prove in respect of the grounds of possession may be proven, does not automatically follow that the court will decide that it will not grant a new tenancy. The court has the discretion, and it must be satisfied that the tenant ought not to be granted a new tenancy. The ought not assessment is not viewed solely from the landlord's perspective. The court is allowed to consider the impact on the tenant if a new tenancy were to be refused. The court is therefore entitled to look at the tenant's past performances and to take into account the tenant's intention and their ability to comply with its proposed future obligations going forward. The court will look back at the tenant's overall performance, including the performance right up to the point of trial. In answering the ought not question, the Court of Appeal in the case of Hazel versus Akhtar took into account both the attitude of the landlord towards strict performance of tenants' obligations and also the tenant's potential loss of livelihood if a new tenancy were to be refused. In that case, the tenant had been in breach of his repairing obligations under the lease, but the landlord's own surveyor had accepted that the tenant had carried out a lot of repairs and that at the date of the hearing of the preliminary issue, the holding was in average condition. Sir Anthony Evans said that the judge in the court below ought to have taken into account the amount of work that the tenant had done to remedy earlier breaches of the repairing ordinance. So it should be borne in mind that last-minute remedies are not a guarantee to a successful outcome for tenants, and their persistent poor conduct can indeed lead to refusal of the grant of a new tenancy. Landlords can rely on multiple grounds together, strengthening their case. The court's discretion under Section 31 of the Act involves balancing equities, landlord's prejudice versus the tenant impact, often favouring tenants due to the Act's protective ethos, but not always. The court must make a value judgment. Is it fair to force the landlord back into relations with his tenant, considering potential future non-compliance? The key from the case of Gill is that even if breaches are remedied pre-trial, a poor historical record can tip the balance. However, the court in Gill granted the tenant a new lease, confident in the tenant's lessons learned and the fact that the tenant stood to lose his livelihood if a new lease was not granted. The same point applying with regard to any of the tenant's future failings to comply with the lease terms. Turning now to look at strategic considerations. Strategically, landlords should consider these grounds when planning opposition. Important thing is to document everything, maintain chronologies of breaches supported by evidence like photographs, emails, and experts' reports. Also important is timing. Raise issues early to build up a pattern, avoiding perceptions of opportunistic opposition. And also do not acquiesce to breaches. Serve formal notices, for example, Section 146 notices under the Law of Property Act 1925 for breach of covenants to evidence the landlord's objection to the tenant's conduct. Strategic considerations now for tenants, and the key is compliance. Regular audits of obligations can prevent grounds from arising in the first place, and also be proactive on remediation. Address breaches swiftly, but understand that historical conduct still matters. Turning now to common pitfalls that we often see include insufficient evidence where landlords rely on mere assertions without proof, or late specification where they've omitted the grounds for opposition in the notice. Another one is the over-reliance on minor breaches, and the courts in the application of the ought not test look for substantial impact. Another one is forgetting that the courts ought not discretion. The landlords assume that proving the factual preconditions is sufficient and it equals success, and that's not the case. In addition, failure to consider cumulative effect, treating grounds in isolation, is one that tenants often forget. Avoiding these requires meticulous preparation, often with legal input. So if a landlord is considering using grounds of opposition, it ought to have an early assessment as to whether its prospects of success are likely to succeed given the circumstances. That takes us to the end of our third seminar in our Commercial Landlord and Tenant series. Should you require assistance with drafting notices, lease renewals, or disputes under the Act, our property litigation team is equipped to support your commercial objectives. Please contact us for tailored advice. In our next seminar, we will assume a hostile Section 25 notice has been served by the competent landlord on the tenant in occupation, and we will dive into opposed lease renewals, focusing on the non-fault based grounds under Section 31D to G of the Act. All that remains is for me to thank you for joining us, and I hope you can join us on our next seminar. A recording of this session and a copy of the slides will be uploaded to our website. We look forward to seeing you for Seminar 4, titled Opposed Lease Renewal, Part 2, Non-Fault Grounds under Section 30 of the Landlord and Tenant Act 1954 on Monday, 10th of November 2025.